You're listening to the Quint's podcast.
Does groping a minor's breasts over her clothes make it any lesser an offence than groping her without clothes? In a controversial ruling on 24th January, the Bombay High Court said that groping a minor's breast without skin-to-skin touch doesn't fall under the definition of sexual assault under the Protection of Children from Sexual Offences Act, also known as the POCSO Act. While acknowledging that such an act indeed is an offence, a sitting judge of the Nagpur bench said that it only amounts to molestation under the Indian Penal Code. These observations came in a hearing of an appeal filed by a man against his conviction under POCSO charges by a sessions court after he was accused of groping a minor's breasts. Now, sexual assault under POCSO is a graver offence than outraging a woman's modesty under Section 354 of the IPC, but while observing that there was no quote-unquote specific detail as to whether the minor's top was removed and whether there was any skin-to-skin contact or not, Justice Puspha Ganediwala of the Bombay High Court acquitted the appellant of POCSO charges, saying that stringent punishments require stronger allegations and proof. Although the court upheld the conviction of the appellant under Section 354 of the IPC, almost immediately after the ruling came, it drew a lot of outrage on social media from celebrities and other citizens alike. While some pointed to the irony in the fact that the judgment came on the same day that is observed as the National Girl Child's Day, others questioned if it's a fair deduction of the law. Doesn't drawing a distinction between the gravity of groping a minor's breasts with clothes and without clothes defeat the whole intention of the POCSO Act? For this podcast, we spoke to Seema Mishra, a practicing lawyer who appeared in POCSO-related cases for both victims and accused. You're tuned in to The Big Story, the podcast where we dissect the headline-making news for you. And I'm your host, Shalpuri. The POCSO Act was enacted in 2012 in a bid to provide protection to children from sexual assault, sexual harassment and pornography, while also safeguarding their well-being through the whole judicial process. It provides for many offences under which an accused can be given rigorous punishments. But does the Bombay High Court's recent observation go against the mandate of the POCSO Act? That's the question that the ruling is raising. Before we get to what all the court said, let's start with what the case is all about. As we've already said, a single-judge bench of Justice Puspha V. Ganediwala was hearing an appeal against the conviction in a case where a 39-year-old man was found guilty of sexual assault by a sessions court for groping a 12-year-old minor. The accused had allegedly brought the minor to his house on the pretext of giving her a guava. He then groped her instead and attempted to remove her salwar. But as the mother of the girl arrived at the spot, she managed to rescue her. An FIR was filed over the incident and the accused was tried under the POCSO Act and also convicted by the Sessions Court. The accused then approached the Bombay High Court to appeal against his conviction. And at the hearing of the appeal, referring to Section 7 of the POCSO Act, Justice Ganediwala said that for any act to be considered as sexual assault under POCSO, the act would have to be 1. Committed with sexual intent, and 2. The act must involve touching the vagina, penis or anus of the child or by the child. Now, although the section itself doesn't specify or distinguish between offences on the basis of skin touch, Justice Ganediwala pointed out that, quote, as such, there's no direct physical contact, that is skin to skin, with sexual intent without penetration, end quote, and therefore the Man's Act doesn't qualify as sexual assault under POCSO. And this is a statement made by the bench verbatim that I'm reading out, quote, the act of pressing of breast of the child aged 12 years in the absence of any specific detail as to whether the top was removed or whether he inserted his hand inside the top and pressed her breast would not fall in the definition of sexual assault. It would certainly fall within the definition of the offence under Section 354 of the Indian Penal Code, end quote. But is this a fair deduction of the offence? Seema Mishra, a lawyer practicing in the District and High Court, explains why such an interpretation of Section 7 of the POCSO Act, as provided by the High Court, is wholly incorrect.
The judgment of the Nagpur bench of the Bombay High Court holding that touching or pressing of the breast of a child without removing her clothes does not amount to sexual assault is a wholly incorrect and bizarre interpretation of Section 7 of Protection of Children from Sexual Offences Act. Section 7 of the Protection of Children from Sexual Offences Act, POCSO, states that Whoever with sexual intent touches the vagina, penis, anus, or breast of the child, or makes the child touch the vagina, penis, anus, or breasts of such person or any other person, or does any other act with sexual intent which involves physical contact without penetration, is said to commit sexual assault. It is interesting that the court felt that the allegations against the accused were proved, but despite that did not think that Section 7 was applied.
Ms. Mishra also points out that the sexual intent behind the man's action is very evident in the fact that he did grope the minor, and to say that it doesn't show sexual intent because there was no direct skin touch disregards the purpose of the POCSO Act.
If you see the facts of the case, they wholly fall within this section. The child has testified that the accused had pressed her breasts and removed or tried to remove her salwar. There is no doubt that there was sexual intent. That is clear from the facts of the case. Then, because the naked breasts were not touched, it cannot mean to say that the child was not sexually violated. To say that because the clothes were not removed, it does not amount to a sexual offence against the child, and the child has no protection under POCSO, is completely disregarding the aims and objectives of POCSO. The judgment has read words in the section which do not exist. POCSO is a comprehensive legislation to protect children against offences of penetrative sexual assault, sexual harassment, and pornography. This offence that has been committed, the facts of this case will not fall under sexual harassment, as that is limited to verbally sexually harassing a child. So it is completely unfathomable. It is completely this means that touching a child's private parts, breasts, when she is wearing clothes, will not amount to any sexual offence under POCSO is, as I said before, extremely bizarre. Hopefully an SLP will be filed and the judgment will be stayed.
Soon after reports of the ruling got out, a lot of citizens expressed their outrage over what the Bombay High Court observed and also disbelief over how the ruling narrowed down the definition of sexual assault. Bollywood actor Taapsee Pannu, for instance, said on Twitter that she had no words to describe her feeling after reading the ruling. Another Bollywood actor, Ritesh Deshmukh, expressed shock, asking, "Is this fake news?" A Twitter user by the name of Mahima Rao also asked, "What about men who grope in public transports? Are those not acts of grave sexual assault?" As Ms. Mishra points out, there is legal scope to stay the judgment, but what message does such an interpretation of sexual assault send to the public at large? If you like listening to this episode, please subscribe to the Big Story playlist for episodic updates. We're live on Apple, Google Podcast, Spotify, JioSaavn, and most of the other popular podcast streaming platforms. For other podcasts, please log on to the Quint website and check out the podcast section. For any feedback, shoot an email to podcasts@thequint.com.
Thanks for listening. Log on to the Quint's website and check out our other podcasts